welcome to the 282nd session of Legal Empowerment Through Interaction lecture series. The journey was wonderful, and we had a short break in between, we thought of having a short break, and now we are back in the 282nd session. And today it's a wonderful topic, that is, whether it be pleadings, whether it be judgments, what will be the judicial proceedings, who will be the stakeholder. It has become a fashion to use a language somebody was saying Latin is Greek to me. So things which may not which an ordinary person may not be able to understand, and judgments running to hundreds of pages, wherein somebody was saying on the lighter vein that we require a decree portion also for these judgments, so that we can understand what exactly is the quintessence of or essence of that judgment. Today, we have a wonderful speaker, Professor P. Bhaskaran Nayar, sir. He's a retired academic, Lincoln University, UK. And to introduce him, we have Alex Zakaria. He was in the Department of Corrections, Pennsylvania. He's it's early morning, I believe that. I'm sorry to wake you up at this hour, maybe 7 a.m. Fine. And to introduce the topic, we have our own family member, Advocate Anil Malhotra, and we are privileged with the presence of Justice V. Ramkumar, sir, Justice Ramakrishnan, sir, Justice Kamal Garewal, sir, and all of you wonderful participants. And without wasting any time, may I first request Alex Zakaria to introduce the speaker, then I'll come to Anil Malhotra, sir, for the introductory remarks, and finally to the speaker, and Justice Ramkumar, sir, will be rendering the concluding remarks. Over to you, Alex.
Hi, friends. I am honored to introduce Professor Bhaskaran Nayar, whom I met several times on my visits to India, when he visits India too. He is a retired academic who has been teaching English communication over 3 continents in many countries. The subject is legalese in... Am I audible?
Yes, yes.
Okay. The subject is legalese in the... I'm getting confused, sorry.
That itself is legalese.
It's
Legalese versus
early morning.
legalese.
See, English is not my mother tongue. Malayalam is my mother tongue. I'm thinking in Malayalam and translating to English, and that is a process.
So as long as Malayalam is not legalese, it's fine.
Oh no, when I want to... Shyam introduced me as a retired from the Department of Corrections. I did not know that is a euphemism. Corrections in America is what in the rest of the world called prison. In other places in the world, it's called prison, it's called incarceration, it's called jail, it's called dungeon, penitentiary. But only in the land of the free, they don't want to call it any of that, so they call it corrections. And I applied for a job thinking that it was something like a counseling or something like that, and I found out it was in prison. And I did not want to go back, so I took a plunge and ended up as a counselor in a prison. Anyway, and someone asked me, do you feel safe here? You got to talk to murderers, robbers, kidnappers, rapists. It's a very dangerous place. I said, look, I live in a house with 1 wife and 3 daughters. So every time I come here, I feel very safe. Come to work. When I come to work. Nobody threatens me outside my home, I said. Anyway, I don't want to keep you from listening to Professor Bhaskaran Nayar. There is a book which Bhaskaran Nayar would probably talk about. It's Ernest Gower's The Complete Plain Words. Nobody reads these books anymore. But that was a book which was introduced, which was written to teach English bureaucrats how to communicate in a way that the communication reaches the subject. I think my 2 minutes are up. He told me to speak, keep it to 2 minutes. I think my 2 minutes are up. I won't keep you from listening to Professor Bhaskaran Nayar. Please.
This is the book Alex mentioned.
Oh, I didn't know Shyam had a copy. I didn't know it had reached Calicut.
No, you need not be in Pennsylvania to have a copy of that. Don't worry. Anyway, it was purchased when I visited you last time. So,
okay.
I would request Anil Malhotra sir to render the introductory remarks.
Thank you, Shyam. Professor Nayar, esteemed panelists, all listeners. Today's topic is something what would legalese interpreted to mean daunting legal terminology interspread with Latin phrases or a smattering of what would say Norman French. Now, these are all relics which the English left and were in a very good way inculcated by none other than the great Justice Krishna Iyer, who would use words or pepper his judgments with words like Jejune, Logomachy. I don't even know the names of these words. So what were they called? It was Krishna Iyer. And then fashion started among judges to start copying these words. I have a specimen of a judgment which I will read to you, where something like this is, so to say, used before I come to the nitty-gritty of how it goes. Now, this is a habeas corpus judgment, and it reads, quote unquote, though up till the age of 7 years, ordinarily the custody of a minor boy or a minor girl can be validly assumed by his or her natural mother, but yet the attempts qua assumption of custody by the aggrieved parent through a writ of habeas corpus being made upon the parent concerned in whose custody the minor boy or the girl aged about 7 years is imperatively enjoins upon the habeas corpus court yet to become seized of cogent and tangible evidence supportive of the factum that the parents concerned in whose custody minor rather is evidently not taking optimum care of all his requirements relating to his nourishments and the best caregivings to him by the parent concerned. One sentence. Another one. Though the evidence is not existing on the record, but yet through the court discharging its solemn judicial functions, its parents portray as also locus parentis towards the minor infant aged about 4 months deems it fit to take the age of the boy minor inasmuch his being extantly aged at 4 months rather than to become the paramount reckonable factor for its ordering for the restoration of interim custody of the above minor infant from correspondent number 4 to his biological mother, the petitioner therein. It's beautiful. But I went to St. John's School, a Catholic school run by Irish brothers, where I learned my grammar from Renan Martin and my writing in Vera Foster. Now, all that we were taught in school was, boys, use short, small, sweet sentences. Be crisp, be brief, and use as simple words as you can. I would say to people today, don't try to be Shashi Tharoor in saying something so simple in so many complicated words that you actually need a dictionary to understand it. Now, this takes me to the farthest end. We have a judge in England. I was doing some research, and I came across Sir Justice Peter Park Jackson. Now, if you read a judgment from an English court, a paragraph is 3 lines, and it is so well split up. Now, this judge was taking care of the custody of 2 children, 10 and 12, whose father had converted to Muslim religion and was trying to smuggle them to Syria on a guise of a trip to Disneyland in Paris, which is another Disneyland. So the court saw through it. He was caught of robbery. He was caught of trafficking in arms. So the judge used emojis to give vent to feelings of expression, items, and other things. So this is perhaps a breakthrough from the world in trying to convey to somebody for whom a judgment is meant to be read as to what the judgment means. So effectively and naturally, now this 17-page rulings concerns use of words which are so friendly to the small child. But then brevity is the soul of wit. Now, though we get it from Hamlet, Act 2, Scene 2, if you go to the original, it's beautifully written. So what does Polonius say? My liege. My liege would mean my lord. My liege and madam, to expostulate what majesty should be, what duty is, why day is day, night night, and time is time, were nothing but to waste night and day and time. Therefore, since brevity is the soul of wit, and tediousness the limbs and outward flourishes, I will be brief. Your noble son is mad. Mad I call it, for to define madness, what it's but to be nothing else but mad. But let that go. So all he's trying to say is your son is mad. It's pretty complicated. But then this is where we coin the phrase, brevity is the soul of wit. So with this small introduction, I would simply say, I think I like what Upendra Bakshi says. He says, a judgment should be 1/3 facts, 1/3 precedents, and 1/3 the reasons. And what you really need is clarity in the school of thought. And you should not use an elephant to swat a fly. This is very important. Now, England is a place where judges retire at 70 and they're letting them carry on till they're 75. So somebody said, I misread it to be they will be released at 75. So now in India, we retire them when they're 65, and that is the real time when we can take advantage of them. So what should the judgment be? It should be reasonable, it should be logical, it should be comprehensible. And as it could be put it, this is something which we need very badly in our country, because I, as a lawyer, think that the judgments from few pages to few chapters sometimes run into a complete volume. And when you agree, it's totally understandable when you dissent. Why should you write just for the heck of it? I concur with my brother, respectfully with my brother, but I wish to say so and so. You've laid down the law and that's but it. So, as has been said by Lord Bingham, judges are quite ready to criticize the obscurity and complexity of legislation. But those who live in glass houses are ill advised to throw stones. The length, elaboration, and proximity of some common law judgments can in themselves have the effect of making the law to some extent inaccessible. This is something very true. Now, I found a recent judgment by Justice Chandrachud, and I think he's put it beautifully. He says, a judgment culminates in a conclusion, but its content represents the basis for the conclusion. A judgment is hence a manifestation of reason. The reasons provide the basis of the view for which decision is espoused, of the balances which have been drawn. That is why reasons are crucial to the legitimacy of a judge's work. They provide an insight into judicial analysis, explain to the reader why what is written has been written. Reasons are open to scrutiny. The validity of the decision is tested by underlying contents and reasons. Equally significant is that a judgment speaks to the present and to the future. Judicial outcomes take singularly or in combination an impact of human lives. Now, I think there is a beautiful summation by what has been said by Justice M.M. Corbett, the former Chief Justice of the Supreme Court of South Africa. He says, for lucidity should be the prime aim of any judgment writer. At the same time, certain aspects of style have a bearing on lucidity. In this connection, my advice, for what it is worth, is keep your language and your sentence construction simple. Write in short sentences. Do not try to pack too many ideas in a single sentence. Particularly in setting out facts, try to maintain a simple, straightforward flow to your narrative. Try to avoid the repetition of words or phrases and observe the normal rules of grammar. I think it could not have been better put. Short, sweet. If you go to the earlier judgments of the Punjab High Court, we inherited the judiciary from Lahore. So we had a lot of judges who were ICS officers, not qualified in law. But what did they write? 3 pages, 4 pages, but so crisp, so clear. Now the same thing is done today in volumes. So be brief, be short, be sweet. That was my job. And now I pass on the mantle back because I will not like to become legalese. I would like to stay in plain, simple English. Thank you.
Thank you, Anil Malhotra, sir. Now, may I request Professor Bhaskaran Nayar, sir, to address us, please.
Oh dear, that was the time that I've been scared of all this time. I must confess that I do feel a little bit intimidated with all those people of law staring at me and talking to them and at them. All I would like to say is I'd say a few words that come to my mind, not necessarily as anything important or scholarly or pedantic, but just my thoughts that come to my mind. And I hope if I do, in the process, try and bore you to death, you will kindly bear with me while I go.
Definitely.
And I don't have very much to do with the legal profession, except that I have quite a few good lawyer friends and a son working as a solicitor somewhere in London. That's all I have. That's all my connection with the legal profession. But so I thought I'd slide slightly off, and because of my contact with the lawyers, particularly ever since I've been coming and visiting to Calicut, I thought I'd also slightly slide on to something that I noticed that I might mention, that you might pass on to other probably younger legal colleagues of yours that might need attention today in our country, because lawyers and the use of English are probably very, very important. Now, there are several reasons, of course, that we need to talk about use of English in the legal profession in India, and some of it have already been covered by people before me. Well, it wasn't anybody's choice, it was enforced on us, as we know. But having said that, as the person before me said, it's not our language, really. In technical terms, if I want to use some high-sounding words, there is no ethno-linguistic grounds for English in India. It doesn't have any kind of ethno-linguistic vitality in India, because except for a few children that grow up in big cities like Mumbai, nobody exclusively talks English. And why is it important? Because people very often have a probably slightly wrong notion. People usually define language as something, as a means of expression of ideas. What they conveniently and easily forget is that's probably a thoroughly inadequate and probably incorrect definition. Because you talk about ideas, they forget that you don't have ideas unless you have a language to have ideas in. In other words, language is not just a way of expressing ideas, it's a way of forming ideas, and it's a way of seeing and visualizing the world into words. And for lack of words, it's a way of creating a world perspective. We don't have an English word for it, so we borrowed one from German. The language creates in what's called a Weltanschauung, a worldview in us. So we see the world in a way the language makes us see it. And therefore, it's not nobody's fault that sometimes India today, particularly in probably the 10th or 11th generation after independence and direct contact with English-speaking world, English today in India is probably losing its standard slightly, and young people do talk something that sounds English. And I very often say, people do seem to talk using English words, but whether they're actually talking in English depends upon how much the English, as the earlier speaker said, come on its own rather than takes birth in another language and then slowly transforms into English. So I thought before I talk a little bit about legalese, which I don't know very much about, it would be useful to point out a few things that I personally observed in my interaction to a lot of lawyers around in Calicut. And I repeat, I don't mean anything bad or critical about anybody. It's just the way things are. And I thought so. I would start with that and how this, one, the standard of English generally in this country is going down. Two, in India, by and large, the school system don't teach people to speak English or to communicate in English. They teach them English literature. I can remember the time when I went to a local university and the vice chancellor asked one of his assistants to take me around and show me around the university. And the young man came out and very apologetically looked at me and said, "I'm sorry, sir, I have an MA in English, but I don't know if I can talk to you in English. Is it all right if I talk to you in Malayalam?" So yeah, he has an MA in English and he probably has a good knowledge of English, how to read it, how to read something in a book, understand it, etc. But the thoughts are not born in his mind in English. And for lawyers, it's particularly important because the legal system and the constitution in this country was conceived of and written in English. And therefore, it has also to be very important, interpreted in English. The interpretation of law as it exists. And when we make new laws also, as far as I know, the official version is the English version. And therefore, the lawyers need to be very well aware of not just English, but also the English that is used in law uses a lot of, as the previous speaker said, a lot of Latin words, a lot of foreign terms, etc., etc. So how something is interpreted in law is very crucial, particularly now I find, don't accuse me if I'm wrong, here now, sometimes I get a feeling that rather than the executive, it's the judiciary that very often rules the country. Because something slightly happens anywhere, people immediately go to court and file a writ petition in front of the court, and the poor judge in the court has to decide how to deal with the thing. So lawyers are getting to be very, very important from that particular point of view. So they have a much better national and societal role than they did ever before, even outside the field of judiciary, I think. So, and as I said, the study of law and the implementation of law, hundreds of words of Latin origin, as was previously mentioned, I don't know. Caveat emptor, crime passionnel, suppressio veri, suggestio falsi, I don't know. Somebody comes and asks for a divorce, and the divorce can be ex parte, it can be decrenici, it can be a mensa irotto. So the lawyer needs to know exactly what these are and what this entails and what this entails. Thirdly, words, we often forget when it's a second language. Most of us, 98% of Indians use English as a second or third or fourth language. Well, I did indeed. When I was a student here in India, English was my fourth language. So what happens is it's very easy for us not to misinterpret meanings in words. Particularly in the legal system, we know words can have a totally different meaning from common parlance, as we all know clearly, that when we study law, we learn new meanings. But for a start, initially, no language has there is a perfect equivalent between meaning and a word. All words mean different things in different contexts. And therefore, particularly in English, I can give you a few random examples. The word trial, contract. When I did my law a long time ago, some 60 years ago, I was taught official legal definition of a contract is an agreement enforceable by law. I didn't know what the hell the definition meant at that time. I was only taught the definition by heart by my law lecturer at that time. It took me a long time to realize, okay, how do I interpret the legal term contract as against the contract used in general parlance? Or argument. Argument in law is very different. I mean, you can make an argument in a court without arguing with anybody. And witness, case, counsel, there are hundreds of words that mean totally different things in law. And therefore, lawyers need to be very careful in the use of second or third language, particularly in most cases when they're also aware of the fact that it's not the language that they initially think in or see the world. So a few random examples, if it might help, that I found very, very crucial for the legal profession from my own personal experience in interacting with lawyers socially and informally. I must emphasize informally. And I think it is important. Some of them have to do with the use of words. Some of them have to use with syntax also. I'd mention 3 or 4 that I think, in my view, I found vitally important. One, of course, is a typical tendency in Indian English to use what are called intensive verbs in the ing form. And you will laugh with me because you may have heard this before. Indians will easily say, I'm sorry?
I'm sorry, it's okay, I'm sorry. Go on, sir, go on.
I didn't get it. Sorry, again, sorry. If I say, I'm having a car, some people say, I'm having a posh car. You would want to ask them, yeah, really? For breakfast or for lunch? Because people very often don't realize that a great deal of words like have or seem, etc., when used in the ing form, can have a totally wrong meaning. Well, if you refer to someone, he's having 3 wives, yeah, one for breakfast, one for lunch, and one for dinner. So have used, so ing use need to be very, very careful. There are quite a few words where ing use is either should be very carefully looked at and should be used only in situations where that's permissible. I mean, it's perfectly all right to say, I'm having a lot of fun. That's fine. But have, when it used, I'm sure all lawyers know perfectly well, when a word like have is used to mean possession, you can't use in the ing form. In the same way, seem, appear, a lot of intensive verbs are used in India generally by people without looking into the possibility of their totally miscommunicating. Secondly, there are lots of vocabulary items that I find is rather strange. I think if it's all right, you're the lawyers, you know better. I find very often in the use, if there's a rape case, the victim referred to as a survivor. Now, I'm not quite sure if that's the right word to use in English at all, because survive essentially means there's a danger to your life. Now, you survive a calamity, you survive a landslide, you survive an attempted murder, but is survive the right word? And in local languages also, a literal translation of the survivor is used. Now, it feels like survivor probably is a term that lawyers might really think about now. Is that really survival? Survival means getting out of death, okay? Is rape comparable to death? It's for the lawyers to decide, I don't know. But to me, it sounds very odd to refer to a person, a rape victim. It's a horrible victimization, but for a rape victim to be referred as a survivor is probably more injurious to the person than to other people because it presupposes that the person was very nearly died or something. And a few other words I thought, a lot of people, even lawyers I found, very often confuse abortion and miscarriage. I'm not joking. A lawyer herself once told me that she was very unhappy when her daughter had an abortion. Now I asked, why? Why did she have an abortion? What she actually meant was not an abortion, but a miscarriage. Now for a lawyer to confuse the two, said, I'm sure that nobody here would do that, But a lot of young people do that. And therefore, we should be careful about when we use a language. More important than using high-sounding words, I think use of wrong-sounding words can be deadlier for lawyers. And I won't say many other things that can be slightly bad as well. People very often ask me here what my good name. That's ridiculous because it's insulting to me. If they ask me for my good name, it also means I have a bad name. Now, I hope I don't. So a lot of things like that we need to think about. And yesterday there was news circulated all around, originated in the United States from Indians, saying there was a fire in Calicut on the backside of Guru Ayappan College. And I laughed because I thought only humans had backside, not buildings. Now, if a lawyer had used that, that would be ridiculously funny. So we need to be careful about a lot of items like that. And then another very interesting example is in India, in Indian English among people, the difference between few and a few is practically disappearing. People don't here very often realize, and it's crucial for a lawyer because you mean exactly the opposite. If you use few, it has a negative meaning, and a few has a positive meaning, and very few people realize that. I saw an advertisement, a huge one-page advertisement in a local newspaper where they had advertised an apartment building saying, oh, it's good, it's wonderful, and then said underneath, few apartments available. Well, if few apartments are available, why are you advertising it? For heaven's sake. What they meant is a few, and very often people send on notes on the telephone, meaning a few when they say few, and the same thing applies to little. I have little money is not the same as I have a little money because they both mean exactly the opposite. One is negative and the other is positive. So in the legal profession, it's very important that people, young lawyers who come up are taught that these things, when you use English, remember these are different. And in a document, if it appears in the wrong way, the lawyer is at fault, definitely. And finally, the use of, not so important, but when lawyers speak, very often, I think the word stress is very, very important, and people completely forget that. You put the wrong stress on the word, and it's a totally different word. I can give you a few good examples. Object is not object. Permit is not permit. Produce is not produce, is it? A project does not project, but then people use the same. And in law, contract is not the same as contract. And petrol is not the same as petrol. The latter is what I put in my car. The first is what a policeman does. And then even the other day, we were laughing at it along with my friends when they were talking about something that to me was heard. They were talking about 4 and 6. To me, 4 and 6 make 10. It took me some time to realize what they actually meant was forensics. And so it's really important that very often, even some time ago, the content is very different from content. I could be very content, but the content I'd be very unhappy with. So they're not the same. So these kind of things, when a lawyer says in a court of law, particularly in front of a judge, etc., can totally miscommunicate. So these are a few things that I thought I'd mention before I go into legal English. What little I know, I haven't got much time. I've probably got another 10 minutes. Right? So have I?
Yeah, sure. Yes, sir.
I talk something, a little bit about the legalese that I can think of at the moment. As my friend S.Shyam knows, my age is catching up with me and I'm starting to forget things. So the important thing is There is a difference, I think, between legal English and legalese. Legalese, as somebody earlier on pointed out, is a way of using high-sounding words, and that's common with all professions. And that's part of a person's tactic, partly political. You use your technical vocabulary and high-sounding words to retain your power. Because when you talk to someone, you want to know that I know what you don't, and therefore my knowledge is shown through this. But unfortunately, as in legalese, as the previous speaker mentioned, the sentences can be very clumsy and very long. I can give you an example of somebody who actually found out in a scientific English, generally, in English dealing with scientific things, an average word length of a sentence is 25 words in a sentence. In journalism, an average sentence has a length of about 20 words. In legalese, you'd be surprised, the average length of a sentence is 75 words.
Oh.
So, you know what I'm trying to say. There is a way. We don't have to do this. This was something introduced to us by English people more than 100 years ago. We are now on our own. There's nothing wrong if we try, as the earlier speaker said, to say things in a way that's simple. And I would say clear rather than the word used by he preferred to use the word lucid, but I'd say even that is high sounding to me. So from that point of view, a legalese is generically a different kind of English. It has complex sentences, overly complicated syntax, full of words like hereinafter, aforementioned, party of the first order, party of the second order, blah, 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 confusing, because the document writer has to retain his authenticity and the client has to be looked like an ignorant person for the other party to retain their power. It's time we did something to change all that and turned it into simple English. There's nothing wrong. But part of the reason for that is from childhood itself, from school time itself, when we are taught English, we are taught in a manner, we are taught a very bookish language. Nobody ever teaches you how English is used in actual communication. You are taught English from textbooks, a highly literate form of textbook. So children grow up with a tendency to use high sounding words. I remember as a student, me saying, complimenting my lecturer, wow, his English is wonderful. Why? Because he used a lot of words that sounded high sounding to me. So I would say from childhood itself, children are taught. If you've listened to children in universities, etc., they always talk about, oh, I've got to submit my assignment. Why? Why not hand it in? They never say, I've got to hand in my assignment. Whereas my colleague Alex will agree that most students in America would say, I've got to hand in my assignment, never submit my assignment. I had a grandniece who was about 8 or 9 years old. She came and told me, oh, Uncle, today we had a wonderful thing in the school. What is it? Excitement. There was a fire. I said, and what happened? Oh, nothing. The fire service came and extinguished it. My God, a 7-year-old girl says, extinguish the fire. Why not put it out? Why doesn't it? Only they came and put it out because she's never taught a simple word. So people submit things, people accumulate, things accumulate, never pile up or add up. Somebody is reprimanded or scolded, never told off. Kids never come home and say, oh, my teacher told me off today. No, my teacher scolded me. Or you never get rid of things, you eradicate things. So from childhood itself, children learn to talk in a language that is not part of everyday communicative thing. It may be all right to use such high sounding words in a totally different level, in a different register. And I'll talk about the level in 2 minutes before I kill all my time. So I can give you an example of what someone, a very highly educated friend of mine wrote to me once, and he had started something new, a new organization, a charity organization, and he was inviting money, funds from somebody. So I'll tell you some parts of it. This is what he wrote to me, a very close friend of his, in English. He says, as per our discussion, what's deemed most conducive is blah, 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 blah. And then he concluded by saying, any contribution towards the enterprise will go a long way in making this venture a grand success. My God, what's happening? Is a friend talking to a friend? That's the kind of English that he used to. And that's the kind of English that we use in terms. And so we have to remember, I often think about it, as I give an example, if somebody is familiar with an author called Woodhouse, P.G. Woodhouse, an interesting author, he has a very famous character called
Jeeves.
Yeah. And his boss was called Worcester. Worcester is from the upper caste. He's aristocracy. And Jeeves is just his valet. And so, but they talk exactly opposite way. I'll give you an example. For example, Worcester would tell, hey, Jeeves, it looks like we'll have to lie a little if needed, don't we? And what do you think Jeeves would answer? He would say, yes, sir. It may be necessary for us to prevaricate marginally should a contingency occur. That's Jeeves' answer. And that's the way, that's what we're talking about, high-sounding English. And that's something that we should avoid when we talk. And so we must remember that talking good, giving good communication is not using high-sounding words. On the other hand, if you do use high-sounding words, it would look extremely funny. It's almost like somebody talking in any Indian language. We talk in ordinary language, particularly in languages like Malayalam, etc. It's now become a tendency, like in English, to use very high-sounding Sanskrit words to make it impressive. And that sounds very funny unless it's an important document. Generally, we linguists say there are 5 keys, what we call 5 keys. And these are 5 levels of formality in communication, in talking. And we call them, we can put at least 5 levels, and we can put them in the order I can say. There's a frozen style, there's a formal style, there's a consultative style, there's a casual style, there's an intimate style. Now, all these we use depending upon who you're talking to, why you're talking what you're talking, and what is the content, what is its area, field, domain, and what is its genre. The frozen style is used in very formal situations. Some of you will definitely have to use it because the frozen style is what's used when a judge is giving out a judgment. It's in a frozen style. Or when a priest in a church is giving out a sermon, it's a frozen style. And next to it, at the next level, we have what's called a formal style. A formal style is when two people meet each other, they don't know each other, and they just got themselves. And so there's a certain amount of formality, and you use a formal style. But then when they get to know a little bit each other and become colleagues, etc., we meet each other, but they're still not very good friends, then that's what's called a consultative style. Now, after consultative style, when you get to know each other reasonably well, you become good friends, you have a casual style. And then when you're very close, like people at home, you use an intimate style. I can give you an example of a statement in all the styles. The frozen style, for example, would be, say, delegates are expected to make your way upstairs using the stairs, if you please. And what's the same thing in a formal style? All people kindly proceed upstairs by way of the stairs. I could say the same thing in a consultative style. As, would people like to go up the stairs now, please? I could say the same thing in a casual style. Time to go upstairs, please. And I can say the same thing in an intimate style if I'm saying to my children, Up you go, chaps. That's how English or any language normally interacts in communication. But what happens with us is, because we have taught English in a very, very artificial situation in literary terms in schools, we're not usually taught any of these, and therefore we use an English that sounds extremely illogically artificial. And in English, as you know, like in Malayalam and some other languages, you can communicate in 3 levels. And at the 3 levels, sometimes the formality goes up, or at least 2 levels. In English, you can talk in Anglo-Saxon, you can talk in French using French words, which is slightly higher, or you can use Greco-Latin. Now, I can quiz somebody in French, or I can ask him something in English. I can quiz him in French if I want to, or I can question him in French, and I can interrogate him in Latin.
Right.
So whether I'm quizzing, questioning, or interrogating depends upon what level I am in. And if I use one, I mean, informally, if somebody asked you, hey, what were you doing? Oh, I was talking to my client. You wouldn't use a fancy word there. Or a policeman talking informally to a person, well, I was quizzing him about something. You couldn't say, I was interrogating him. But that's very often what happens and what sounds like when we talk and we use English. So in legalese, very often, is there a reason? Is anybody?
No, no, it's some interruption,
Sorry?
some other extraneous interruption.
So in legal English, this happens very often because sometimes it has to be in frozen style. A lawyer talking to his witness in a court of law would probably use a consultative style and at best a formal style, but never a frozen style. A judge interfering in it would use a formal style, but use a frozen style when giving out the judgment. But instead, if the judge and lawyer uses a frozen style, even in simple interaction, it looks highly artificial. And therefore, before we make fun of legalese or legal English, we must understand that legal English does exist like any other English. There's medical English, there's engineering English, technical English, computer kind of English. In fact, I did make a career, I did make a job for about 5 or 6 years in England teaching something called ESP, which is English for Special Purposes, which was a craze in those days. And that is, you will have a 10-day course for engineers, another 15-day course for lawyers, etc. So yes, you do have a language that is specific to a profession, to an area, to a genre. And when I say genre, what kind of writing it is. One kind of English if you're writing a thesis, another kind of English if you're writing a letter, another kind of English if you're writing something that is part of a propaganda, etc., etc. But to use a kind of high-sounding, fancy word English when it's not necessary at all, when it's not normal at all, is extremely funny. So I think we need to be a little bit aware and careful about it. And as people who are in control of things, you should do something to make sure that the young people don't do this anymore and they're being made aware of all these. And I'm sure you can all do that in your own way, because people of your generation hardly are guilty of most of this. And I may have exceeded my time. I'm so sorry. I have bored you to death all this time. So thank you very much for listening to an old man talking about his mad theories. Thank you.
Thank you, sir. In fact, I don't know how to say, because I mean, whatever word I might be using may not be in the correct sense. So I will just pass on the baton to Ramkumar, sir. Play safe.
Oh, we heard some good English today. What really is English? What we are used to is only Manglish, an admixture of Malayalam with bad English. In fact, I was reminded of a situation where a person who was showing his friends the newly built house, he showed them the formal living, showed them the bedroom, showed them the kitchen, showed them the living room, the bedroom, then came to the store, finally came to the kitchen to say that This is my wife's private part. This is our English.
I don't know how many people here understand or talk Malayalam, but I give usually people an example in Malayalam for those who understand. Indian English very often, like, think of a rustic country farmer asking his wife, instead of asking, supposing he asks her, Bhavati, Gokalka, Tranavam Jalavam Pradhanam Jaiduvo. That's exactly what it sounds like very often in the way people use English. And so we need to be aware of this, and we need to know the 5 clocks or the 5 levels and modify our language. Otherwise, communication can very often be very, very funny, very tricky.
Yes. You rightly said that we use English out of necessity, probably to interpret the Constitution. Most of the statutes, laws are all in English. And Article 348 of the Constitution of India says all official languages in courts shall be in English. So that will be the authoritative language is English. That is why we are forced to use English. But unfortunately, we don't use real English. That's your problem.
I know. And English words, I remember I was young at that time in Mumbai. I still remember the time when the Indian Parliament spent, I think, 3 or 4 days discussing the Constitution to change whether to use after 1960 English shall continue or may continue. For the use of one word in the place of the other. They disputed for 3 days and finally decided it's not may, English shall continue. And that change in one word meant legally a hell of a lot of difference for the whole lot of Indians.
Sadly. I was amazed by the language of Lord Denning. The simple, lucid English. In fact, I tried to imitate the great Lord, but without any success, because I was already habituated to the other type of English. Excellent articulation, sir. Thank you.
Thank you, Ramkumar sir. Ramashan sir.
As really Padman has said, I'm afraid as to whether I will be using the apt words. When I'm talking to Bhaskaran Nayar about the way in which he has put how the English should be used in the regular way or in the legalistic way. As rightly said, when you go to school, we are not talking English. Usual English or casual English, what is required. If it is a casual English that is being taught in this school or taught in this school, then the students will be knowing about the casual words or regular words that is being used in a common parlance to make the communication easy. That is not happening. What is happening is you are going with some dictionary and you are reading some books and you are explaining those words which are being used in the books for the purpose of understanding what the language is. That is one reason, the basic reason why people are not able to communicate properly in an easy way. I can say it in an easy way to understand. And another thing, people are thinking that they are reading for the purpose of using that reading knowledge in some place where they can utilize it. That also causes some difficulty when the judgments are coming up. As Malhotra has said, when Justice Krishna writes a judgment, he tries to impose all the knowledge he has imparted on account of his wide reading and also his wide knowledge in the subject which he can to be communicated to people whom they are not that much intelligent or that much understandable way. That there is one thing happens. And rightly said, the language has to be used depending upon the platform which you are using also. Suppose you are going to a rusty people to talk about something. When you use high words, I don't think that they will be able to understand. So you will have to come down to the level of the people who are before you And purpose of the judgment is to make know the reasonings that has been given in your judgment to the party to the litigation. Whether you are succeeding in that is a question to be considered. That may be the reason why now there is a tendency that you will have to have a translator version of the judgments in the regional language so that people may be knowing about it. What the judge has said about the case, what the reason, what the logic that has been given by the judge for the purpose of arriving at the conclusion, either in favor or against. So these are all the areas where even as rightly said, that you have 3 days discussion and ultimately the may has been changed to shall. In the constitution, the English should continue because you don't have an alternate language which may connect the entire thing. Now they are trying to have an alternate language, but people are not able to have a consensus on that as whether that can be accepted as a common language. Unless you arrive at that the commonness freely, I don't think that we will be able to have because when you dictate judgments in local language, it will be around that area alone. Suppose you want to rely on the same judgment by somebody else, I don't think that there will be a copy available unless it is translated in English and given to the other people. So this is the area where some common language will have to be sorted out first for the purpose. That is the reason why the Hindi and English was taken first.
Yeah, well,
Either Hindi or English.
I know. I'm not talking about the politics of it. I'm talking about the language.
No, I'm not also that. I am also at that only now coming because unless you are able to, unless the even if you go in Kerala, I think there is one judgment has come when the law was enacted in Malayalam without an English version. That was set aside and sent back that you will have to have an English version because the constitution demands it.
Yeah.
Because people are very much conversant with the language in which it was usually being done. That may be the reason why this happens. One. Secondly,
Now, thanks to artificial intelligence, you get the judgment in all languages.
but quite unfortunately, I do not know how far it is properly.
Very bad translation.
So the CGI is already thinking of neutral judgments, neutral citations, and SCR is available to everybody. So there may be a time very soon when we will have judgments in all languages. What the chat GPT does or what AI does is absolutely incomprehensible.
Now you are familiar with WhatsApp language, text language of WhatsApp.
When I was a student, my ideal of good English at that time was V.K. Krishna Menon, and I even worked in Mumbai for his election in the 60s.
Anyway, it's a good lecture as to how you will have to formulate your language for the purpose of making the communication easy, especially the lawyer community. Thank you, sir.
Can you invite Justice Garewal, please? Shyam?
Sorry?
Shyam, can you invite Justice Garewal, please?
Yeah, in fact, Justice Kamal Garewal, please.
We need to see you because you must speak up because I think you are a very good literature come legal expert.
Please, sir.
Can you see me?
No,
Yeah,
sir,
we
you
can
can't.
see and hear you, sir.
You can
You
hear
can
me,
only
but
hear me.
why is that? You know, I'm on my iPhone. Where I live, there is connectivity is very poor.
Anyway, sir, your words will be wisdom.
So at the moment, yeah,
The expression will be in the picture, in the words.
So it's perfectly okay. We can
good
see
evening.
and
Please carry on, sir.
Good evening, everyone.
Good evening.
I'm an old fossil. I'm a midnight's child. So that will place me in September 1947 when I was born. But I was made in Lahore. So
Manufactured in Lahore.
Manufactured in Lahore, but born in India and Missouri. So anyway, that apart, having been a judge and having been a lawyer before that, I have an interest in plain language or plain English, because now it is well recognized that English is not a good language for judicial work. I think Professor Bhaskaran Nayar may agree that there are other languages like German is very good. German is very brief and very precise, but English is not. And the English we have in our judicial work is from England, and England got its laws from the French. When the Normans took over England in 1066, they brought their laws Old French. So the concepts were Latin in Old French, had to be explained to the Anglo-Saxons. So every time they said something had to be said 3 times. We often have this bad habit. The order of the lower court is ultra vires, void ab initio, and so on. It just goes on and on. They can't say it is illegal or something. Short. So with that, all the legislation became complicated, because lengthy, because it had to be in 3 different styles. And then so did the deeds, the conveyance deeds and the agreements and the insurance contracts. If you read your insurance contract today, it is so complicated, you don't understand. You just go and sign it. You borrow money from a bank, you just go and quickly sign it. You don't read the kind of clauses that have been introduced in it. Anyway, that apart, I'm a votary for simple English, plain English, and as Professor Bhaskaran said, 25 words is the judicial average. I think even less than that, it can be 18 words. And it's very easy to write 18 words in a sentence. You just count. The moment you reach 18, you put a full stop and start again. So you don't have to carry on and on and on in the same. It's easy to read. Your writing should be easy to be understood, difficult to be misunderstood. But here, many times you come across sentences which run into half a page, and then you've forgotten where you started from and where it ends. So the whole thing gets very confusing. It's very hard for judges to go through this kind of pleading, and sometimes the lower court judgments are also so badly written. They may be correct, but they're so badly written. It's a pain in the. It's a pain.
Nether regions.
So I would, and there is a active movement for plain English all over the world. I know in Australia and New Zealand, they have a plain English commission, which is simplifying the language of the bank documents, for instance. And bank documents now are very, very simple to understand. Earlier, they were not. And there's a plain English language, plain English movement in US and also in England, of course. And Justice Michael Kirby is a champion of that. And if you like, I had a friend when I was working with the UN, there was a judge from the US who actually taught legal writing. His name is Mark Painter, and he has written many books on legal writing. And he's got his rules of legal writing, that's quite interesting. I can share with Anil, and then he can share with everyone else.
Yes, sir.
So
Yes.
it's very, very important, And unfortunately, all our top judges, I'd say 90%, write such long judgments that we get so taken in by their very scholarly person, but all he's done is cut and paste. The judgment is 100 pages. 5 pages are his words. 95 pages are from here and there. 20 pages from the pleadings, then from the lower court, and then other judges' judgments are quoted. They don't tell the reader what they find important, which is the sentence or which is the principle which emerges from those, but they quote 2-3 pages from the previous judgments. So it gets very difficult, and this habit is very hard to get rid of. It has to be taught early. Young lawyers must learn to write plain English, must practice it. It's not easy to write briefly. In fact, writing a long judgment is much quicker than writing a brief one. Because in brief one, you have to understand what the concept is and then put it down precisely. We used to have, in the old days, Anil will know, précis writing. We have to write a précis. So that is what it is. We must write briefly, and it has to be practiced. In fact, law schools should introduce legal writing as a subject and have English professors coming and teach how the legal work should be done for more effect. And I think it's a very interesting conversation and very nice, very informative from Professor Bhaskaran. And there's another book by Gowers, is Modern English Usage, which is also always kept ready for consultation. And we have a book by Lynn Truss, Eats, Shoots and Leaves, which is a guide to punctuation, actually. How a misplaced comma or a full stop or a semicolon can change the entire sense of what has been written. And there is a well-known case of Roger Casement, who was actually hanged by a comma. So the judges went to a 1300 AD law and found there was a comma there, actually. It was in Old French, and they found there was a comma. And by placing the comma there, it became an offense. And Roger Casement was actually hanged for that. And he was a knight. He was Sir Roger Casement. And after 30, 40 years, his body was taken back to Ireland and given a state burial. So that's, I think I better have taken enough time of everyone. And I'll close now. And thank you again very much, Anil, for inviting me. I really enjoyed it. Thank you very much.
I must share something what Justice Kariwal said on what I have met Justice Michael Kirby thrice in Australia. Now, Justice Michael Kirby has written a piece on writing of judgments, and he says very beautifully, brevity, simplicity, and clarity. These are the hallmarks of good judgment writing, but the greatest of these is clarity. Now, these are just 3 sentences. Look at the beauty of these sentences. It's so well crisply put. Now, I must also share with you the concept of writing long judgments, the concept of writing long paragraphs, and the concept of writing so many things is emerging. Why? Honorable judges at all levels in all courts have 8 to 10 law clerks. First are interns, and then law clerks. Now, it is the job of these clerks and interns to collect material. So these young people who's fresh out of a 5-year law college accumulate the material. Now, it looks so good, it looks so nice that you don't bother about the length of the judgment. So all this material is cluttered, and in it is lost relief. The client or the litigant wants to know, what is the relief that I've got? He's not bothered about the 70, 80 pages which is written. So this culture of assisted writing through the system available facilities is now perhaps a reason or a cause. I know I am privy to some things which I cannot divulge, but this is a problem which is coming through. So you think there is so much good material, it looks so nice. And then as Justice Garewal said, it's like it's infectious. It travels. So everybody wants to adapt to the same style, but it's no good. I would still go back and read old judgments of the Punjab High Court before we split into 2. Go to the 60s and pick up a law report and see 4 pages, 3 pages, 2 pages. And sentences.
Privy Council judgments.
I have seen Lord Denning use 1 word. Dr. Balram K. Gupta is whom I called the Indian Lord Denning. And he's the one who has actually adapted his style very well. One word sentence. People say it's not complete, but then when you look at it in the context, you realize that it means a lot. But you can actually write, as Professor Nayar said, 75 words. We need to change. Lady Arden, judge of the Supreme Court in England, has said that we have to look at how we are going and what we are adapting to the future. I got a quote about what she says, and I just read it out to you because it makes a lot of sense. Now she says, the law cannot stand still. It must keep pace with changes in society. Law provides the framework within which the members of society and economic actors operate. It provides guidance for endeavors, public and private, and sets the parameters of lawful behavior. If the law falls behind times, it cannot perform these functions properly. Now, this is a very, very well-meaning thought process. You have to change. We can't keep looking at Anglo-Saxon terms with Latin phrases and difficult mythological words. You should not have the need to have a dictionary with you or Google with you to find out what this word means. I think use of such words should be absolutely done away with in judgments. And the role is with the judicial academies. They should be the ones, if the law colleges haven't done it, the judicial academies in the state and the Judicial Academy of India in Bhopal should do regular programs on judgment writing. This is something we have forgotten. This is akin to what we used to have, Department of Legislative Drafting. The English made these departments. So before a law was drafted, there were legislators, there was a Department of Legislative Writing who would write the law. Nowadays, clerks write the law. That is why we have so many challenges to the law, and nobody understands the law. And as Justice Garewal put it rightly, for a IQ level person of a clerk, putting a comma or a full stop may mean nothing, but it can change the whole course of law. So we need to actually bring in legislation back into the system with the help of experienced people. I was privy to helping the government of Punjab in drafting the Punjab Compulsory Registration of Marriages Act and the Punjab Prevention of Human Smuggling Act. Now, when we drafted the law, Professor Nayar would be one person who would say, what do you mean human smuggling? So, human smuggling means illegal trafficking of persons with consent of the person. So, in this context, the people who were agents who were registered under this act said, we are known as human smugglers. This is not a very nice name to be known as. So we changed the name to Punjab Travel Professionals Regulation Act. They said this one is good. So the terminology is changed. But when we sat down to make the laws, I realized how difficult it is to make the law. But use of English language, plain, simple, and understandable. Back to Shyam.
Sir, nowadays, nobody dies. Either he expires, passes away, or I don't know what all happens to him. But nobody dies nowadays.
He passed away. Exactly. You don't use the word, as Professor Nayar would say, backside. Backside can be a very wrong connotation. But you don't speak the North Indian language. Our Punjabi language is very expressive. one sentence or one few words can be very, very exciting. We had an Irish Australian brother in our Irish school called Brother Meredith, who used to train for football in schools in the evenings. So I remember when in the evenings the school team would be training or a match would be going on, he would be refereeing the match. And if somebody missed a goal, he would speak to him in English and the guy wouldn't bother. But then would turn around the captain and let out a volley in Punjabi. What did you just say to him? He said, nothing. He says, what you said was very effective. So it is the effectiveness of the language, though it may be abusive or vulgar, it's communication. As Professor Bhaskaran and I would say, communicate. If you read the Hindu, there is a column on an inner page, a long column, it comes daily, know your vocabulary. There, the author of the column discusses all this. He explains words what they mean and how they mean. I read it daily. It's very interesting. So you should catch on with it, and then
It
you will
comes on
understand.
Tuesdays or Wednesday or something like that. Tuesday or
Correct.
Wednesday.
Sir, can we just open up for Hamza Amir is waiting to say something?
Yeah, sure.
Hamza, please.
Hello, everyone. Good evening. Sir, I had a question for Mr. Bhaskaran, and I wanted to ask him, since I'm a final year law student, whenever I've been interning, I have noticed that when you are mentioning matters early morning at 10:30 a.m. in front of the Bombay High Court, you have to be very crisp and fluent, and in 15 seconds, you have to communicate to the judge what is the urgency in the matter. Now, what I struggle with is fluency of communication, in the sense that when I'm talking to someone with on something that I'm not prepared with, there are a lot of and I'm thinking for the right word. I'm struggling with articulation. So I wanted to ask you as to what are there any practices that I can use so as to communicate myself without without stopping, without pausing, in a tone, in a pace that is that the other person doesn't has to be patient to get my point, so that I can just in one subtle sentence without too much preparation. Because when I have to brief my associates, I have to prepare at night, I have to practice in front of the mirror multiple times so that I can express it to him in 5 minutes what the matter is about. But if I'm not prepared, then he'll send me back because there are so many pauses in between. So I wanted to ask you, are there any practices that I can take up?
I don't see any problem with your communication. You're communicating very well as it is. So I think it's a more psychological than linguistic matter. So all I can suggest is try communicating with friends, and preferably with some friendly person who is you consider slightly superior or higher, because that seemed to balk or stop your ability. Because at the moment, there's no problem at all. You're saying everything you want to say very clearly. So if you practice talking what you want to say with somebody that you're friendly, and then at the same time, is probably slightly higher in knowledge and status than you are, maybe a senior or somebody, that psychological block would automatically disappear, I think.
So, and another thing, Hamza, sorry for interrupting. Hamza, I would suggest to you, I've been a lawyer for 38 years. It's called court fever. You get very excited, you get very worked up, and in the process, you lose all those words which you have in your head. Try to be relaxed. And as you go over the years, you'll master the art. Well, you're talking of mentioning, I'm talking of a fresh matter before the Supreme Court on Monday or Friday on a new day. All you get is 2 minutes. So if you're able to say the right words in that right span of time, in as many little words as possible, and as important as possible as the judge thinks, you've got it. So this is something you will get by experience. Don't worry. Don't be nervous. Don't be tense. But my advice to you is relax, go relaxed. Because if your mind is cool and calm, you'll be able to say all what you practiced. And as Professor Nayar said, do it with friends. Do it more often. Practice makes a man perfect.
Thank you. I mean, tomorrow onwards, I believe that Hamza would be, what you're going to do in the court, I would like to see.
Totally different person.
So,
Hamza, if you are married, try speaking in front of your wife. You'll get away with it.
That's the best way. Now,
That's a dangerous thing.
Alex, if you want to add something, we can wind up because we are already now. It's nearing 6:30. Alex, please.
Just one thing I wanted to clarify, Professor. When people say good name, that's a literal translation of the Hindi. Aapka shubh naam kya hai? That is literally translated. That's how the good name comes. And Justice Ramkumar, forgive me for saying so, but when you heard an extraneous noise, we just heard an outside voice.
Yes. Again, the same illness.
Sir, Professor Alex is pulling your leg now.
Yes, same illness. It's part of the same illness.
He's pulling the judicial leg.
I understand.
Anyway, thank you very much, guys. I was so I wish I had I've recorded it and played here for many people here. There's no copyright violation, right, Shyam? If I played for some judges here.
I would use the word, I will contemplate and let you know later.
Oh my God.
I will contemplate it. I will contemplate and let you know the consequences.
Consequences.
Which flow from the
Alex.
legal recording aspects.
But one author I would definitely recommend is George Orwell. George Orwell, his writings, along with Ernest Goes's The Complete Plain Words. These are.
And also, Alex, this is also good. If Hamza would like to have a look at this. This is plain language for lawyers.
Hamza, don't get into these professors. Go to your wife and say, I want to practice. She will teach it to you.
Friends, so friends, it has been a wonderful evening. And as we come to the end of the 282nd session, let me first thank Professor Bhaskaran sir. Please, sir, thank you very much for being part of this family, because we have been interacting in the last 281 sessions. This is an open platform wherein we exchange ideas, we ignite ideas, and maybe out of it something good may come out. And today I would say it was a evening well spent, in the sense, like, I mean, we were exposed to, sir, a wonderful and entirely, I mean, I never thought that if I say something in this manner and the other manner, petrol and petrol, it's petrol for me. And for that, many other words like that. Thank you for enlightening us, or rather, sir, I don't know which term to use. If I use enlightening, then again, it is something like lightning. So I don't want to use that. So thank you, Justice Ramkumar sir, Ramashan sir, Kamal sir, and Anil Malhotra sir. Alex, thank you very much for waking up early in the morning, and I think it's office time right now. Or
It's a Saturday.
Oh my, see, that's wonderful.
I work for the state government, so my going to work and not going to work doesn't make any difference at all. It's a waste of taxpayer money. That's all.
As it is here.
So thank you all, and till we meet again next time, please use simple, plain English, or for that matter, any language. And just to conclude, I don't know whether it's a true story or not. Kapil Dev, when he became the captain of the Indian team, somebody asked him, because we had players from different parts of the country, and at that point of time, it is said, I'm not sure whether it's correct or not, his English was very poor. So how do you communicate? He just said, I say, you understand enough. Thank you very much. Till we meet again next time. Do take care and stay safe.
Thank you.